Hello students, welcome to EPG Pathshala. I am Prakash Sharma from Faculty of Law, University of Delhi. Today we are going to discuss about a module Women in Prison under paper Women and Law subject Women Studies. The objective of present module are to ensure full understanding of prevailing conditions of prisons, needs for its improvement particularly concerning women. Second, realizing the aims and objectives of human rights vis-a-vis a special attention on rights of vulnerable section of the society. The scheme of presentation will include an introduction, then human rights and international perspective, third, rights of women prisoners in India, fourth, social profile of women in India, and thereupon conclusions and suggestions. The prison system was primarily designed and run by men for incarceration of men. Thereupon, as the society developed further and role of women were seen in the political and social setup of any society, the prison system received women too as in prison inmates. In every country of the world, women are a small minority of those incarcerated. As a result, they find themselves held in facilities and under conditions that at best have been poorly adapted for them. At worst, they are of same as those of men. The recent past has seen expanding population of women who served a sentence due to more expensive law enforcement efforts, stiffer drug sentencing laws, and post-conviction barriers to re-entry, thereby affecting women. The need for understanding and therefore appreciating rights available to women prisoners is must. Women have very different needs from men. They require specific health needs both for themselves as well as their children, especially for those children who are born in prison and thereupon. Although women remains a small percentage of total number in prison, their numbers are growing and there is increasing concern among penal reformers about the problems and how to work to improve their situation. Women are entitled to equal enjoyment and protection of all human rights in political, economic, social, cultural, civil and other fields. Human rights and international perspective. Human rights by definition belongs to everyone based on their humanity without regard to conduct or status or any gender. The key human rights documents are very clear in their statement of the intrinsic dignity and worth of human person and made no exception for those who have broken the law or otherwise violated the social contract. The significance of these rights to people deprived of their liberty is also clearly spelled out in the Universal Declaration of Human Rights, especially covered under Article 2, 3 and Article 5 of UDHR. Further, the International Covenant on Civil and Political Rights, 1966, through its Article 3, states that the state parties to the present covenant undertake to ensure equal right of men and women to the enjoyment of all civil and political rights set forth in the present covenant. Similarly, Article 6 and 7, with its combined reading, states that no one shall be subjected to torture or cruel, inhuman, or degrading treatment or punishment. Article 10, 13, and 26 Similarly, International Covenant on Economic, Social, and Cultural Rights, 1966, through its Article 3, provides that state parties to present covenant must undertake to ensure equal right to men and women to the enjoyment of all economic, social, and cultural rights set forth in the present covenant. The covenant lists number of economic rights under Article 6 and 10, which talks about social rights such as protection and assistance to family rights, to marriage with free consent and of intended spouses, special protection for mothers after childbirth. Cultural rights are protected under Article 15. The covenants and conventions that followed from UDHR, ICCPR, and ICESCR further elaborated these rights and gave them the specificity to create the legal framework that defines how states should treat their citizens. The Declaration on Protection of All Persons from Being Subjected to Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, 1975, through its Article 2, upholds the concept of human dignity, human rights, and fundamental freedom applies equally to both men and women. The Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, 1984, through its Article 2, 4, 5, 6, 7, 8, 10, 11, 12, and 13, clearly talks about relevant provisions related to detained people. However, in the said convention, there were no express provisions favoring the rights and interests of women, but the convention as a whole provides for equal treatment without any discrimination on the ground of gender. Similarly, provisions are found in European Convention on Human Rights 1950 through its Article 3 and American Convention on Human Rights 1969 through Article 5. Women are a minority in prison systems, and because those systems are generally designed by and for men, women are inherently unequal and their specific needs are given short shrift in many instances. The body of Principle of Protection of Persons under any form of detention or imprisonment 1988 incorporated 39 principles. Few important principles among them are Principle 1, 4, 5, 10, 11, 20, 34. Principle 5 states measures applied under the law and designed solely to the protection of rights and special status of women, especially of pregnant women and nursing of mothers, children and juveniles, aged, sick, or handicapped persons shall not be deemed to be discriminatory. The need for and the application of such measures shall always be subject to review by a judicial or any other authority. The Convention on Elimination of Discrimination Against Women, 1967, directs all appropriate measures to be taken to ensure to women equal rights with men in field of economic social justice through Article 10, which emphasizes on social justice for women. The Convention on Elimination of All Forms of Discrimination Against Women, CEDA, 1979, speaks for equal treatment. The preamble of CEDA acknowledges existence of extensive discrimination against women and states such discrimination violative of principles of equality and human dignity. Under Article 1 of CEDA provisions, discrimination against women is described. Article 2 contains measures to eliminate discrimination against women. Article 3 calls for appropriate measures in for full development and advancements of women, granting to them the exercise and enjoyment of human rights and fundamental freedoms on the basis of equality with men. Article 11 of CEDAW provisions urges states to take appropriate measures to ensure rights on the basis of equality of men and women. The Declaration on Elimination of Violence Against Women 1993 declares human rights of woman and girl child as inalienable, integral and indivisible part of universal human rights. Violence against women was treated as violation of rights and fundamental freedoms of women. The Optional Protocol of Convention on Elimination of All Forms of Discrimination Against Women 1999 through its Article 8 on this discusses about systematic violations of women's rights. The committee has also made it necessary to designate one or more of its members to conduct an inquiry and report thereupon and accordingly transmit findings that with recommendations to state parties. India is not party to this particular optional protocol. Now we will be discussing about certain international minimum standards for treatment of women in prison. First, we will be discussing about United Nations Standard Minimum Rules for the Treatment of Prisoners, 1955. Part 1 of the Standard Minimum Rules for Treatment of Prisoners dealing with rules of general application, in its rule number 6, talks about non-discrimination. It also discusses about through under rule 8 that categorization of prisoners to be kept in separate institutions or parts of institutions taking account of their gender, age, criminal record, the legal reason for their detention and necessities for their treatment. Rule 8, Clause 1 postulates as far as possible men and women shall be detained in separate institutions. In an institution which received both men and women, the whole premise allocated to women shall be entirely separate. Rules 22, 23, 24, 25, 26 talks about medical facilities. Now, Rule 23.1 emphasizes for having pre and postnatal care and treatment facilities, also arrangement to be made where children are born in hospitals outside the institution, and should also provide a birth certificate without mentioning the place of birth if child is born in a prison institution. Rule 23 Clause 2 draws emphasis on childcare. Further, it suggests recruitment of qualified nurse staff. Rule 53 Clause 1 laid down therein that institutions set aside for women should be under the authority of a responsible woman officer who shall have the custody of keys of all part of the institution. Clause 2 restricts entry of any male member in such part of the institution. Rule 53 Clause 3 provides that women prisoners should be attended and supervised only by women officers, provided male functionaries like doctors and teachers within their professional duties can carry out their activities in such institutions or part set up apart for women. Part 2 of the standard minimum rules for the treatment of prisoners deals with prisoners under sentence, insane and mentally abnormal prisoners, and prisoners under arrest or awaiting trial. General provisions with no gender bias are suggested by United Nations for the prisoners mentioned in the above criteria. The Basic Principle for Treatment of Prisoners 1990, through its Principle 1 and 2, discusses that all prisoners shall be treated with respect due to their inherent dignity and value as human beings, without any discrimination on the ground of race, color, gender, age, language, religion, political or other opinion, nationality or social origin, property, birth, or any other status. Principle 5 signifies that all prisoners shall retain the human rights and fundamental freedom set out in Universal Declaration of Human Rights, and where the state concerned is a party, the International Covenant on Economic, Social and Cultural Rights, and the International Covenant on Civil Political Rights, an optional protocol thereto, as well as other rights are set out in other United Nations conventions. Principle 7 suggests that efforts should be made and encouraged for abolition of solitary confinement and punishment or for restriction of its use. The United Nations Minimum Rules for Non-Custodial Measures 1990, also known as Tokyo Rules, through Part 1, Principle 2.2 advocates on non-discrimination. Principle 3.2, while emphasizing on legal safeguards, states that the selection of non-custodial measures shall be based on an assessment of established criteria in respect of both the nature and gravity of an offense and the personality background of the offender, the purposes of sentencing and the rights of victim. Principle 3.9 talks about dignity of an offender which shall be protected at all times. Part 6 emphasizes on staff and its recruitment and training. Part 7 under Principle 17 calls for public participation. Part 8 talks about research, planning, policy formulation and evaluation. Principle 23 emphasizes on international cooperation with respect to non-custodial measures. Rights of women prisoners in India. The management and administration of prisons fall exclusively in the domain of state governments and is governed by Prison Act of 1894 and prison manuals of respective state governments. The states have the primary role, responsibility and authority to change the current prison laws, rules and regulations. States have the obligation to protect against and punish violence against women, whether perpetrated by a private or a public actor. States have a responsibility to uphold standards of due diligence and take steps to fulfill their responsibility to protect individuals from human rights abuses. Detained people are included within the definition of human rights because human rights extend to all human beings. It is a basic tenet of international human rights law that nothing can put human being beyond the reach of certain human rights protections. The basic right of life, health, fairness and justice, human treatment, dignity and protection from ill treatments of tortures remain irrespective of discrimination. In India, even Supreme Court has spoken about the subhuman conditions that exist in our prison system. In Shatrughan Chauhan versus Union of India 2014, this particular aspect has been dealt by our apex court. Another important observation made by court is in Nilabatti Behera versus State of Odisha 1993 case, wherein a realistic approach concerning fundamental rights, which is in consonance with international commitments, were dealt with and extended to even a foreign nationals. The Supreme Court has laid down three broad principles regarding imprisonment and custody in Prem Shankar Shukla versus Delhi Administration 1980. Apex Court held that handcuffing as an inhuman and unreasonable practice, more so on a woman offenders. Sunil Batra versus Delhi Administration 1978, the Apex Court held that solitary confinement violates the fundamental right guaranteed by Article 21. In D.K. Basu versus State of West Bengal 1997, court held that any form of tortures or cruel, inhuman or degrading treatment would fall within the inhibition of Article 21. In Husainara Khatun versus Home Secretary State of Bihar 1980, the court held that protective custody of women witness for exporting evidences is violative of principle of right of life and dignity. In Khatri versus State of Bihar 1981, State Supreme Court found out that state cannot avoid its constitutional obligation of providing free legal services on the basis of financial or administrative inability. Sila Bursi versus Secretary, Children Aid Society 1987, court issued guidelines which has to be observed for the protection of constitutional rights of women prisoners. In Upendra Bakshi versus State of Uttar Pradesh 1981, Supreme Court, while listening to social action litigation, held that the existing barbaric condition of detention in Agra Protection Home is unjustified and against the principle of Article 21 of our Indian Constitution. Few things which need to be kept in mind are that firstly, any person in prison does not become a non-person. Secondly, a person in prison is entitled to all human rights within the limitation of imprisonment. And lastly, there is no justification for aggravating the suffering already inherent in the process of incarceration. Article 14 and 15 of Indian Constitution provides for equality and non-discrimination on the basis of gender, and Article 21 provides protection of life and liberty of an individual. The All India Committee on Jail Reforms 1983, Section 25, from page number 207 to 213, deals with women prisoners and the Committee of Empowerment of Women in 2001 and 2002 have also highlighted the need for a comprehensive revision of prison laws. Also, the Expert Committee on Women Prisoners, constituted by government in 1986-87 under the chairmanship of Mr. Justice V.R. Krishna Iyer, made a number of very useful recommendations for women prisoners and suggested a national policy for custodial justice for women. It laid particular emphasis on the need for adoption of specialized approach towards handling, treatment and rehabilitation of women prisoners. The Model Prison Manual for Superintendence and Management of Prisons in India, prepared by Bureau of Police Research and Development (BPRD), which comes under Ministry of Home Affairs, Government of India, has also under Chapter 24 from page number 254 to 274 has talked about women prisoners. The National Human Rights Commission is also a body established for protection of human rights, and under Section 2D, the definition of human rights is defined. Also under Section 2F, International Covenant is defined, which means International Covenant on Economic, Social, Cultural Rights and International Covenant on Civil and Political Rights. The provisions of Prison Act 1894 nowhere mentions about women prisoners in particular, meaning thereby it applies to every prisoner irrespective of their gender. Chapter 3 of Prison Act 1894 talks about duties of officers employed in prison. Chapter 4 deals with admission, removal and discharge of prisoners. Chapter 5 talks about separation of prisoners. Chapter 8 deals with health of prisoners. One important provision under Chapter 11 of Prison Act 1894 is Section 46, which deals with prison offences and its punishment, wherein it is specifically mentioned that female along with civil prisoners is not subject to imposition of any form of handcuffs or fetters or whipping. We will discuss few rights available to women in prison and accordingly analyze them. Right of a pregnant woman. A pregnant woman should not be sent to prison unless there is absolutely no alternative. If this has to be happen, special arrangement needs to be made for them while they were awaiting the birth of their child and also during their nursing period. Particular sensitive issues concerning the application of any security restrictions during the actual birth. Women inmates undergo intensive emotional stress during the separation of their families. In response to a public interest litigation, the Supreme Court in R.D. Upadhyay vs. State of Andhra Pradesh 2006 formulated guidelines regarding pregnancy, antenatal, childbirth, and postnatal care and childcare. The presumption should always be that no expected mother will give birth inside a prison. In this regard, Para 13, All India Committee on Jail Reforms, recommends for pregnant and nursing women prisoners to be prescribed special diet and exempted from unusual types of work. Para 1.18 of Committee on Empowerment of Women 2001 and 2002 emphasized on similar need for women prisoners. Para 24.20 and 24.21 of Model Prison Manual laid down guidelines for pregnant women in prison. Childcare. Women prisoners are often the sole or primary carer of minor children. It is common in many countries for babies and young children to be taken into prison with their mothers. This may well be preferable to separate them. However, it also raises complex issues about facilities available to such children to ensure their own appropriate development, including physical, mental, and emotional. In this regard, Para 13 of All India Committee on Jail Reforms recommends that children up to the age of 5 years to accompany mother prisoners and may be allowed to be kept with them in specially organized creches outside the main prison building. And under Para 13 of the committee recommends that registration of birth of child to a woman prisoners, the place of birth should not be mentioned as prison. Instead, the name of locality should be mentioned. Under Para 13 of committee recommends that every newly admitted woman prisoner should be medically examined for pregnancy. Pregnant women prisoners should be transferred to local maternity hospital at the time of childbirth. Rule 23, Clause 1 of United Nations Standards for Minimum Rules for Treatment of Prisons 1955 recommends the same. Para 1.19 and 1.16 of Committee of Empowerment of Women 2001 to 2006 emphasize on the principle on similar need for women prisoners. Para 24 of Model Prison Manual laid down guidelines for childbirth in prison. Further, Para 24, 20.26, 24.27 and 24.28 of Model Prison Manual laid down guidelines for care for children in prison. Also, Para 24.29, point 30, point 31, 32, 33, 34 of Modern Prison Manuals laid down guidelines for welfare of children and matters related to their education. The impact of their mother's imprisonment on the child affects every aspect of their lives and not only their relationship with their mother. Not surprisingly, it often leads the children into aggressive and antisocial behavior. In India, various decisions of courts have been emphasized on need for proper care for children of those women who are serving prison terms. Meeting with relatives. It is one of the basic rights of a prisoner to receive meetings with relatives and friends. It is necessary for them to stay in jails near their home so that visitors find it convenient to come for meetings. There has to be one separate interview room in central jail for the women inmates. Certain belongings like Mangal Sutra bangles are allowed to be kept by the women prisoners, and the same was recommended in Para 13 of All India Committee on Jail Reforms. Para 24.86 of Model Prison Manual calls for separate room for visitors and waiting room for women in prison. Healthcare. Women prisoners have specific health needs which have to be recognized and attended to. Wherever possible, they should be attended to by a woman nurse, and doctors and specialists in women's healthcare matters should be available for consultation. In many cases concerning about their children will be a great cause of worry and stress for women prisoners, which will have a significant impact on their mental well-being and make imprisonment psychologically more painful than it is for the men. Healthcare arrangements available to women prisoners should reflect upon that. Para 13 of All India Committee on Jail Reforms recommends need for proper healthcare for women prisoners. Rule 22 to 26 of United Nations Standards Minimum Rule for the Treatment of Prisoners 1955 also recommends the same. Para 1.20 and 1.29 of Committee on Empowerment of Women 2001 and 2002 emphasize on similar needs for women prisoners. Para 24.15, 24.16 and 24.17 to 24.19 of Modern Prison Manual laid down guidelines for women health. Under Section 24 Clause 3 of Prison Act 1894, the medical examination of female prisoners has to be done by a matron under the journal or special orders of medical officer. With regards to clothing and bedding of to civil and unconvicted criminal prisoners, Section 33, Clause 1 of the Prison Act provides that every civil and unconvicted criminal prisoner unable to provide himself with sufficient clothing and bedding shall be supplied by a superintendent with such clothing and bedding as may be necessary. Further, for maintenance of certain prisoners from private sources, Section 31 of Prison Act 1894 provides that a civil prisoner or an unconvicted criminal prisoner shall be permitted to maintain himself and to purchase or receive from private sources at proper hours food, clothing, bedding, or other necessaries, but subject to examination and to such rules as may be provided by Inspector General. Section 54 of Code of Criminal Procedure Code 1973 provides for examination of body of an arrested person by a registered medical practitioner at the request of arrested person in case of torture and maltreatment in lockups, to be lodged in separate buildings. Para 13 and 18 of All India Committee on Jail Reforms recommends establishment of special institutions or annexures meant exclusively for women prisoners to be established. Rule 8 of United Nations Standards on Minimum Rules for Treatment of Prisoners 1955 also recommends the same. Even in 1919, Indian Jail Committee for the first time emphasized on need for separate institutions for female prisoners. It was ironical that the recommendation made by this committee could not be implemented due to unconducive political environment. Para 1.16 of Committee on Empowerment of Women emphasized on the similar need for women prisoners. Para 2, 9, 24 and 24 of Modern Prison Manual lays down guidelines for special institutions for women in prisons. Under Section 27, Clause 1 of Prison Act 1894, the female should be imprisoned in separate building or separate part of the same building. Right to be staffed by a woman person. Keeping in mind the needs and requirements of women, the All India Committee on Jail Reforms recommend that all persons and annexes for women must be staffed by personnel. Further, under Para 18 of the committee recommends that whenever women personnel are admitted in sub-jail, arrangement for appointing women guards on purely temporary basis should be made. Also, Rule 53, 1, 2 and 3 of United Nations Standard Minimum Rule for the Treatment of Prisoners 1955 recommends the same. Similarly, Para 1.3 of the Committee on Empowerment of Women emphasize on similar need for women prisoners. Para 24 of Modern Prison Manual laid down guidelines for women personnel to be appointed for women in prison. Free legal aid. Women prisoners are entitled to free legal aid and counseling, and legal cells are wherever they have been operating in jails in states or union territories. In few states, social workers and psychiatrists have also been appointed to provide counseling to women prisoners. However, the counseling cells are not uniformly available to women prisoners all over the country. Even by the available constitutional mandate of Article 39A. Para 1.20 and 1.40 of Committee of Empowerment of Women emphasize on the similar need for women prisoners. In Para 1.31 of Committee on Empowerment of Women, a need for special court or lok adalat for offences which are not so serious in nature and which can be tried in a court expeditiously and cases of under trial could be disposed of is been mentioned. Para 24 of Model Prison Manual laid down guidelines for legal aid for women in prison. Section 303 of Criminal Procedure Code 1973 empowers the prisoners to be defended by a pleader of their choice. And Section 304 of this code provides that in certain cases legal aid is to be provided at the state expense. Section 309 of the Code of Criminal Procedure Code 1973 provides that in every inquiry or trial, the proceedings shall be held as expeditiously as possible. The social profile of women in prison. The women prisoners across the globe have one thing in common: a background of social disadvantage. In Apparel Export Promotion Council versus A.K. Chopra, 1999, court ordered certain appropriate measures to prevent discrimination against women and steps to be taken to protect the honor and dignity of women was emphasized upon. Moreover, the Prison Act 1894 is too old. It contains no provisions regarding welfare of women prisoners. In terms of rehabilitation, educational or vocational training, counseling, drug or alcohol dependency programs, women prisons are disadvantaged compared to men's establishment. This is due to lack of funding and in part to a lack of programs designed or adopted specifically for women. For women prisoners in India, most jails, there is no scheme for proper and appropriate vocational training and non-elementary education for women prisoners. In some jail, education means being taught the alphabet with little emphasis on its applicability. Despite the scarce provision made for education and work programs for women prisoners, the value placed on them is high, not only in terms of qualification they may receive, but for the psychological and emotional benefit that they confer. The Para 10 of All India Committee on Jail Reforms recommend for special attention should be paid to the development of suitable educational programs for women prisoners. Further, Para 13 recommends adequate and proper work and treatment programs for women in prisons. Para 1 of Committee on Empowerment of Women emphasizes for need for women prisoners. Para 24 of Modern Prison Manual laid down guidelines for education, recreational and cultural programs and need for vocational training for women in prison. Conclusion. Clearly, we have largely ignored the international consensus on incorporating human rights based standards and norms into our policies and practices, often through misunderstanding from human rights framework and a lack of awareness about what it has to offer. Also, many a times being ignorant of rights available. The prison remains hidden from society with no national standards, no national system of inspection, and no required national system of accreditation can achieve any benefit unless they are made known and open to public. The Convention Against Torture, which the India has signed and ratified, now has an optional protocol that provides a mechanism for international and national inspection of all places of detention. It would be of a great example to the rest of the world if we had the confidence to sign that optional protocol and open places of detention in India to inspection by experts versed in international standards. We can just hope that at some point international law will provide a basis for litigation in our courts to enforce the requirements of the treaties that we have signed and ratified. Few suggestions. Women prisoners shall be detained separately from male prisoners. Women prisoners shall be supervised and searched only by female officers and staff. Pregnant women and nursing mothers who are in prison shall be provided with special facilities which they need for their condition. Whenever practicable, women prisoners should be taken to an outside hospital for giving birth. No male member of staff shall enter the part of institution set aside for women unless accompanied by a woman officer. Women prisoners shall be attended and supervised only by women officers. There shall be a special accommodation for all necessary prenatal and postnatal care and treatments. Thank you.